Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin LLP. As you see on the screen, I'm located in Toronto. And as you know, we do many of these question and answer sessions every week. And the goal is to get as many of your employment law questions answered as possible. We have offices in Ontario, in Vancouver, British Columbia, and Calgary, Alberta, and we host these information sessions across our provinces. And again, we want to try to get the public educated on their employment rights. And so now is an amazing opportunity for you to ask all of your employment law questions, and I will try to answer as many of them as possible. It's great to be with you all again. And as I usually do, I would like to start off by talking about an important topic in employment law, and then we'll delve into some questions after that. So the topic I want to raise are layoffs happening at IBM. I'm sure you've heard of the company IBM. It's a massive organization, and they have said that they are going to trim down, or in other words, lay off many workers in the marketing and communications division. It is entirely unclear at this point how this will affect Canadians, how many Canadians might be impacted by these layoffs, but I'm sure we will see that information come to light very soon. And we know that some people working for IBM and other technology companies and other companies in general, they might be classified as independent contractors. Okay, I'm sure as well that's a term you've heard of. So what's an independent contractor? An independent contractor is a worker that is not an employee. And they're supposed to have more flexibility and autonomy and control over the work and their hours. And presumably they should be able to work for more than one employer. Now, I come across many cases frequently where we have a person who is classified as an independent contractor and who's terminated, their contract is terminated. And then this person comes to me and they say, am I entitled to severance? And so what I tell these people are, if you are a contractor, no, you are not entitled to severance. You have to be what's considered an employee or another designation, which is known as a dependent contractor, to be entitled to severance pay. But most individuals are misclassified. There are many people out there who are classified as independent contractors, meaning they might have signed an employment contract that says that they're an independent contractor, but in fact they're not. And the law considers more than just what you sign in terms of determining whether you are an employee or a contractor, and therefore whether you're entitled to severance. Our firm has assisted many individuals who, again, were classified as independent contractors, were let go from their positions, and they were in fact deemed to be employees, and they were entitled to their full severance pay as a result. So if you're in this kind of situation, please make sure that you contact us. You can reach us at help@employmentlawyer.ca. And there's a solid chance that you are, in fact, an employee or what's called a dependent contractor. You'll be entitled to your severance pay. So it's not just about the contract you sign. It's not about whether you remit your own HST. There's more to the analysis than just that. Okay, so for all the viewers, very important to keep that in mind. As promised, let us delve into some questions that we have. So we'll start off with a question we have posted on Facebook from NAF. NAF says, I'm 64 years old, working for a company for 39 years. Unbelievable. Current salary is $82,000. Company got sold a few days ago and are under new management. What are my options if I don't want to work for the new management? Okay. So if the company gets sold, and the new management, the new company, if it's a new entity, a new company, they decide to take you on as an employee, then you'd work for that new entity, that new employer, and arguably your your entitlement to severance would still exist from the previous employer. Okay. If for some reason the position is, let's say, very different, or there are other various reasons why you may not want to work for the new entity, then in most cases it is going to be your previous employer who has terminated you, and therefore you're entitled to your severance pay from that previous employer. Now, if you do move to the new entity, the new management or company, and you work for them for several years, and they terminate you, then they are the ones liable to pay you your severance, the new company. So it depends on whether you start working for that new company or not. Now, if you do start working for the new company, you have to make it clear, and it should be clear in any document that you have to sign, if you do have to sign a new document, that your entire tenure of 39 years is going to be recognized for all purposes, including calculating severance pay. So it can't be that the new company you work for is going to not consider your previous 39 years of service, and you're going to be starting from scratch. That would be a very, very detrimental thing for you. So you don't want that to be the case. So make sure that if you are presented with a new agreement, first of all, we're happy to review it. And it's very important, in fact, that you have a lawyer, an employment lawyer at our firm, review this document, so that we ensure everything is done properly, your tenure is being recognized. If you are entitled to some sort of severance from the previous employer, that you obtain that severance. So these issues could be complicated, and that's why it's very important that you have our assistance if you're going through this. So Naf, I hope that answers your question. If you have any follow-up, please make sure to post it in the chat. So we have another question on YouTube from Lucy. The owner of my company is a very uninformed person as it relates to employment law. I've recently had to let go of a couple of staff, and when speaking to him and HR, explaining to them common law severance as to be fair to the employees, I was told, we will fight until they run out of money and they will never win. He takes everything to court and drags it all out. Can they do this? I guess they can do it. Employers might make foolish decisions, and that would be a foolish decision. But they shouldn't do that. Usually the wise decision is to come to some sort of amicable agreement as to what the severance will be. It is usually not worth having to go through a full legal proceeding in order to obtain severance, because severance is something that an employee is entitled to, and it should be that the company and the employee, and perhaps with lawyers involved, are able to figure out how much severance the employee should get without having to drag it out through years of litigation. So Lucy, I hope that answers it. If you need any help, we do also provide those kinds of services. So please reach out to us, and we can arrange a consultation, talk more about this issue, and be of assistance to you. Okay, let's move on. We're getting a lot of great questions today. We have a question on YouTube from BB Smooth. My employer has decided to stop paying travel expense. I calculated my costs, and it will be about 14% of my annual income that I will be out of pocket to pay for mileage. Can my employer do this? Good question. So this leads us into a discussion over what is called a constructive dismissal. Constructive dismissal is a situation that is very common, where an employer is not terminating an employee outright. They're not giving you a termination letter saying you're being terminated. But what they're doing is they're changing in a fundamental way aspects of the terms of your employment in a manner that you don't agree with. So, for example, in BB Smooth, in that case, they're changing his pay structure, his or her pay structure, right? And if that's going to represent a loss of 14% of the annual income, that is arguably a constructive dismissal, a significant change to a key term of employment, the key term being how much someone is paid. And that significant change can be treated as a termination. So BB Smooth, you would be able to treat that as a termination. In other words, it would be a constructive dismissal, and you'd be entitled to your full severance pay as a result. And we can certainly help you with this. Now, we'd have to learn more about exactly why they're pulling back on travel expenses. Perhaps there's a plausible explanation. But that's why let's arrange a consultation. Let's talk about these details, and we'll see how to go from there. On the topic of constructive dismissal, like I said, unfortunately, it's very, very common. And a constructive dismissal could be a change in pay, like in the case of BB Smooth, or it could be a change in hours, a change in job location, a change in duties, all of these types of changes that are significant. If you as the employee don't agree to the changes, and you don't have to agree to them, then you can treat the changes, if they're being forced upon you by the employer, as a constructive dismissal. Another common one we deal with all the time is a layoff. If the employer lays you off and you don't agree, and even if the employer says it's just temporary, we hope to call you back. If you don't agree to the layoff, it's another situation of a constructive dismissal, and you can pursue your full severance pay. Now, in order to evaluate the case, we of course would have to look at your employment agreement, because it could be that the employment agreement allows the company to make certain changes, such as lay you off or change your pay, or change your hours, etc. And so long as the employment agreement is done properly, then those changes would be legal. Most of the time, the employment agreement is not done properly, and so often those changes would be illegal, regardless of what the employment agreement says. As you saw on the screen, we review contracts all the time, and it's a great service that we provide. It doesn't have to be that you have been terminated in order to get our assistance. We will help you if you have a new job and you're provided with an employment contract. Let us review it so that you understand what you're signing, and you're not left with only understanding it. Perhaps if you're terminated years later, you find out, oh, that's what I signed. Now my severance is only a certain amount of money because I signed that in the employment agreement. There's many things that you have to understand before you sign an employment agreement. So we're happy to review those. So BB Smooth has a follow-up. What should my next steps be then? Do I say to my employer that they're constructively dismissing me with this change? At what point should I start speaking to a lawyer? You should speak to a lawyer right away before you say anything to your employer. Let's arrange a consultation, and we can, again, learn more about your case and advise you specifically on what next steps would be. Okay? Don't jump the gun and say something that can hurt your case in the end, though. So let's arrange that consultation. As you've seen on the screen, contact us at help@employmentlawyer.ca. And another great resource is our website, employmentlawyer.ca. We have tons of resources on there on all of these topics. So if you want to learn more about them after you learn about the topics today in our consultation, in our Q&A session, then please check out the website, employmentlawyer.ca. Okay, let us move on to a question on Facebook from Jeanette. I have worked 30 hours a week for the last 10 years now. My supervisor reduced my hours to 21. I do not agree to this, but it has been imposed anyway. Is this something my employer is allowed to do? So Jeanette, this is a perfect example of what we were just talking about, a constructive dismissal. If your employer is changing your hours, your employment agreement doesn't permit your employer to do so, and you have not allowed your employer to do so. You haven't said something to the effect of, I understand why you're reducing my hours, I accept it, or I consent to it. If you do not agree, you don't accept it, you don't consent to it, then yes, you can challenge this, and it would be a constructive dismissal, and you would be able to pursue your severance pay as if your employer said you're terminated, Jeanette, right? Great question, and again, unfortunately, a frequent thing to occur. Okay, let's move on. We have a question from Dave on Facebook. Can an employer punish you for swearing in the workplace? Does this not infringe on your rights? Okay, so this is a good one. If you are swearing in the workplace, your employer can send you a warning. They might express to you why swearing is inappropriate for the working culture. I don't know if it's, when you're speaking to clients or customers or just with your colleagues that you swear. Context is obviously very important. But I would not be surprised if your employer, if they have an issue with it, if they provide you with a warning. It should be in writing. And if you continue to breach it, then what might happen is your employer will terminate you for cause. Termination for cause is where your employer says, you've engaged in misconduct, we warned you about it, and now we're letting you go, and we're not paying you the severance you're otherwise entitled to because of your misconduct. Now, many, many times, the employers are severance, and they shouldn't be doing so, because even if there are some sort of issues, for example, performance issues, or in Dave's case, maybe he swore one time in the workplace, and then the employer says, we're terminating you for cause. In most cases, that wouldn't be a sufficient reason to let the employee go for cause. They can let you go without cause, which means they're just letting you go and they're paying you your severance, and it has to be the proper amount of severance. But to actually withhold your severance pay, you have to, as the employee, have engaged in really serious misconduct. Otherwise, your employer won't get away with that. And we challenge those things on behalf of employees all the time. I have many, many, many cases that have come across my desk where an employee is terminated without severance, the employer is alleging cause, and the reasoning just isn't good enough. A great example of that would be your performance is lacking. You didn't meet certain targets. We're not happy with your performance. We're letting you go, employee, with no severance. That's not going to cut it. The law is very clear on that point. And so if that is a situation you find yourself in, absolutely contact us. Let us assess whether the company really does have cause to terminate you from a legal perspective. And if not, we will absolutely assist you with getting the severance that you're entitled to. So Dave, I hope that answers your question. And if you have a follow-up, then please feel free to post it. Okay. So we have a question on YouTube from Ladder. My employer is 2 weeks late on paying staff. We haven't received a real explanation why. How long is an employer allowed to be late? So there's no exact rule that your employer owes you your wages. If you have an agreement that they pay you biweekly, then they owe you it biweekly. And if they're late, that's a problem. The Ministry of Labor might be able to help you with this. They should be able to help you with this. If it becomes an ongoing issue, then absolutely contact us and we will assist with the problem. So Ladder, I hope that answers your question. And if you have a follow-up, please feel free to post it. Okay, so we have a question on YouTube from Rem Style. I am taking some time off to take care of my father while he has chemo. Sorry to hear that. My employer has started asking all sorts of information about his treatment. What sort of information can they ask for? So they shouldn't be asking for all sorts of confidential medical records of your father. It's not relevant to whether or not they have to accommodate you. If you need time off work to help with your father and his treatment, there are human rights laws that protect that, right? And if your employer is not accommodating you as a result, then they're in breach of those human rights laws. Now, for them to ask for some sort of reasonable proof that he's actually sick or something like that, perhaps is fine. But if they're skeptical and they're constantly berating you to ask for evidence about your father's treatment, then that's a real problem. And you should absolutely contact us because your employer should not be doing that. Again, very important, your employer has to accommodate you to a level that is very high. It's called undue hardship to the employer. And so if they're not doing so, we will help with that. and we have a lot of experience dealing with these kinds of human rights issues. So please, REM style, contact us and we'll arrange a consultation. And we'll assist with next steps based on what your employer is doing. Okay, let us move on. We have a lot of great questions. Let's move on to a question from Brittany on Facebook. In the next few years, I'm considering retirement after about 20 years in investment banking, currently management director level. Should I be able to negotiate an exit package? So an exit package is technically separate and apart from a severance package. Severance package is something you're entitled to when you're terminated. An exit package could be it is a situation where you and the employer, for one reason or another, are agreeing to end your employment. Your employer isn't necessarily terminating you. But either way, exit packages are quite common. They typically reflect severance anyway, although they're a bit different. So yes, Brittany, you should be able to negotiate that. Certainly if your employer actually lets you go, even if you don't expect it, then you will be entitled to your severance pay, absolutely. And if they don't decide to let you go, but you both agree that it's time for your employment to come to an end, then yes, you can arrange an exit package, and we will be more than happy to assist you and advising you further about that. Okay. As you see on the screen, we have a link to our tool, Pocket Employment Lawyer. So you'd find that at pocketemploymentlawyer.ca. And we've been talking a lot about severance during this Q&A session. And I've mentioned full severance pay. So what does that mean? I'm sure many viewers are trying to understand, what does it mean, full severance pay? Well, every situation is different, first of all. So you should understand that one person's full severance pay is different from another person's full severance pay. Because the way that severance is calculated is by evaluating one's age, length of service, the character of their employment, so the type of job that they're doing, how much money they're earning. And these are the things that are used to determine how much severance one should be entitled to. Now, if you check out our Pocket Employment Lawyer tool, we have what's called a severance pay calculator. It's free and anonymous, so you can use it and you can find out how much severance pay you would be entitled to given your particular circumstances. I always encourage people to use the tool, even if you haven't been terminated. If you have been terminated, certainly use it. If you were just curious to know how much severance you would be entitled to, use it. And it will ask you very simple questions. What's your age? How long have you worked for the company? What is your position? And it will tell you how much severance you would be entitled to if you were terminated. Very, very helpful tool. Like I said, free and anonymous. And then after you use the tool, if you have been in fact terminated, contact us and we will help you obtain the severance pay that our calculator says you're entitled to. Okay. Let us move on. So we have a question from Wisdom, Love, and Spirit on YouTube. They say, I'm 55, 13 and a half years employed. I was a mass layoff 2 days ago, non-union position, clerical. Online calculators, as I was referring to, severance pay calculator, say I should get 10 to 16 months. Also heard up to 19 months. They offered 11, my opinion. 11 is a bit short. It's not a terrible offer, but it's certainly short, and we can help you improve that. So your entitlement is closer to that 16-month amount, and we will help you obtain that. So absolutely contact us at help@employmentlawyer.ca. We'll arrange a consultation. We'll gather the documentation that we need, and we will promptly contact your employer to negotiate. If you accept their package of 11 months and you sign the documentation, then you will not be able to negotiate. A very important thing to note, I review termination documentation every day. Almost every single termination letter is going to set out a deadline. If they're offering you severance, there's going to be some sort of deadline in that letter that says you have to sign this package by a certain date. And if you don't, you're going to lose a whole chunk of your severance. So don't worry about those deadlines. In most cases, the deadlines are completely arbitrary. It's a pressure tactic that employers use to get you to accept the severance offers that they're making. And that's not true, that you have a week or 2 weeks or 3 days or whatever deadline the employer is giving you to negotiate your severance. You have 2 years to pursue your severance entitlement. That is the amount of time according to the law. So if you are within the first 2 years of termination, absolutely. If you've not accepted a package, you can negotiate your severance. So very, very important to note that those deadlines, you should not succumb to that pressure. We will help you negotiate the package, and you'll be off to go after that point. So wisdom, love, and spirit, absolutely contact us for a consultation. Okay, let us move on. We have a question on YouTube from Maheen. I've been terminated for cause after 7 years of work for a major bank, no severance package. What should I do? Am I eligible to severance? I haven't signed anything. My manager just sent me the letter, let me go. Yes, so absolutely contact us. Like I talked about earlier, it's very common to be terminated for cause. Sometimes your employer does have cause for termination, and often they don't, even though they say they do. So let us review the particular circumstances of your situation, Maheen, and I will let you know whether there is cause for termination or not. And if there isn't, then yes, your employer will owe you a certain amount of severance, and we will help you obtain that. So contact us at help@employmentlawyer.ca, and we'll arrange that consultation. Okay. We have a question on YouTube. I discovered I was wrongfully dismissed after 2 years. Can limitations apply? Yes. So as I mentioned earlier, if it's been more than 2 years since your termination, then it is unlikely that you're going to be able to pursue this case. Now, there are certain exceptions. We can review your situation to see whether you can pursue this, but there's a good chance that you won't be able to pursue it. You have a 2 year period after termination to pursue it. It depends when this occurred, and there could be, as I mentioned, some exceptions. Okay, so contact us and we'll review the details. We'll obviously need to know the date of the termination, see the termination letter, and figure out if you have any entitlements and whether you can pursue them at this point. And lastly, we have a question from Candice on Facebook. What happens if you're forced to accept a package under duress? So yes, if you are coerced into accepting a severance package, they give you no time to review it, they give you no time to seek any legal counsel, and they force you to accept it, then there very well might be duress there, and your signature on that package, on that severance package, will not be valid, and you'll be able to pursue further severance. That certainly we need a consultation to review the case, why you think you were under duress when you signed the package. Okay. So I hope today's session was helpful. We got through many very important employment law topics and questions. Thank you for all your questions. And I will be back very shortly. We have another Q&A session tomorrow at 1 p.m. with my colleague Thielen, and he will pick up from where I left off with any further questions that the viewers have about employment law. So thank you very much. Take care, and we'll see you soon.